but the other hand, in the case of better late than never, it's really important to talk about the issue because it has been persisting since the beginning of the armed conflict in Ukraine in 2014. And this has been one of Russia's probably most effective instruments of persecution and punishment of the Ukrainian military and civilian population. So today we're going to have a video talking about the issue in general to give you a bit of a understanding what we're going to be talking about today. And then we will hear from the Prosecutor General of Ukraine, Mr. Deprivation, and he will give some key points on the situation in Ukraine. And also we have Olga with us, and then we'll hear from Mr. Andriy, he's the prosecutor from the War Crimes Department, and also the Prosecutor General of the state. And then we'll hear from the three brilliant Stella experts who will be talking about the legal classification and also the actual situation on the ground as well. So let's begin. Let's start with the video.
These verdicts are not representative.
The Russian Federation is deliberately looking for the guilty.
Every Sunday, the Ukrainian capital has been buzzing for over 6 months now. This is an action in support of Ukrainian prisoners who Russia has been holding in its prisons for years. Each week, Svetlana Logosha comes to all these events with her poster. Her son, 22-year-old Vadim, has been in Russian captivity for more than 2 years. At the beginning of the full-scale invasion, he was a recruit of Azov. In Mariupol, he was preparing to take a young fighter's course. But on February 24th, 2022, he was forced to take up arms and defend the city from the invaders, together with other servicemen. Vadim was later besieged at the Azovstal plant, from where, by order of President Zelensky, he surrendered to captivity. The International Committee of the Red Cross guaranteed the safety of the Ukrainian military's surrender from Azovstal. The relatives of the Mariupol soldiers believed that they would be released in 3 to 4 months. However, Vadim's captivity, like that of more than 1,000 other defenders of the Mariupol garrison, continues to this day. During this time, the Russian Federation began to put Ukrainian soldiers on trial. For example, Vadim Logosha and his fellow soldiers were sentenced by Russia from 24 to 26 years in prison.
Encroachment on the lives of civilians, invasion of the territory, and I don't understand which territory, and also destruction of civilian dwellings. 3 articles.
Svetlana Logosha does not know where her son is now. She learned about the verdict from the Russian media. She never received any letters from her son. She is terrified of looking for a lawyer in Russia to file an appeal.
Vadim was sentenced to 24 years. And if, for example, I had the idea to appeal, I do not believe that the term would have been reduced, but rather increased. It is possible that it would be extended to life imprisonment. We have military guys from the Azov who have already been convicted twice. One for 24 years and then for 27 years. Another was sentenced to 26 years and then to life. I think they pass sentences on Ukrainian servicemen every day. We can see this in the reports of the Investigative Committee of the Russian Federation, which says that today they handed down a sentence of 25 years, yesterday 28, and the day before for life.
Tatiana Katrichenko is a journalist and executive director of the Media Initiative for Human Rights. This Ukrainian non-governmental organization, among other things, researches where Russians are holding Ukrainian prisoners and interviews them after their release. So far, the organization has interviewed more than 200 soldiers released from captivity, and they all say the same thing. Representatives of the Russian Federal Security Service and the Investigative Committee of Russia not only invent crimes for them, but also torture the prisoners and force them into incriminating themselves.
The servicemen we interviewed say that during interrogations, they are told, if you don't know, make up a crime. The Russian Federation is deliberately looking for the guilty, deliberately turning prisoners of war into guilty of certain war crimes. They do not have a goal to find the cause of the death of a certain civilian. They need to find at least someone guilty. Russia has been acting in this way for almost 10 years, since the beginning of the military conflict in Donbass in 2014. During this period, the Kremlin has only improved this system. With the outbreak of a full-scale war, the convictions of prisoners of war have become a mass phenomenon. Their sentences are longer. At the same time, the trials themselves do not always occur on the Russian Federation's territory. Sentences are often passed in the occupied territories.
This was done by a court that was not established in accordance with international law. Secondly, the judge is usually a collaborator, so to speak, who has actually sworn allegiance to Russia and therefore is a priori biased. In other words, a prisoner of war is judged by someone who has committed treason in various degrees.
One of those who went through all the stages of the so-called Russian justice was Bogdan Pantyushenko. He served as a tanker and was captured near the Donetsk airport in early 2015. He spent almost 5 years in captivity. He was held in basements for half of that time. The trial began only in the summer of 2019. Bogdan says that no investigative actions were conducted with him. During several interrogations, the investigators simply let him read the part already written in the indictment.
It looked very funny. The investigator asked me, "Did you serve in the armed forces of Ukraine?" I said, "Yes, I did. Were you provided with, for example, boots?" I said, "Yes." "Did they give you a uniform?" "Yes, they did." "Were you fed?" "Yes, I was." "Were you given weapons?" "Yes." "Okay, thank you." The verdict: I participated in the terrorist organizations.
Bogdan recalls that the only court hearing was even funnier. It lasted only 15 minutes. The prosecutor, for some reason, read the verdict, while the judge was engaged in her private activities.
I'm sitting close to the judge and his secretary, and I could hear them talking about beauty salons and discussing where and how to do nails best.
In the so-called Donetsk People's Republic, Bogdan Pantyushenko was sentenced to 18 years in a maximum security prison, in particular, for serving in the Ukrainian armed forces. He was released in late 2019 during the last major exchange before the full-scale invasion. Bogdan believes that the prisoners currently being sentenced by the Kremlin to long terms will also soon return home through exchanges. However, in addition to the return of people from captivity, Ukraine and the international community have an equally important task to investigate and prosecute those responsible for crimes committed against Ukrainian prisoners of war, such as torture, detention in inhumane conditions, and illegal convictions.
So I think we are ready to hear from the prosecutor general. The floor is yours. Hold on, no sound. No sound.
Sorry. Thank you.
Okay.
Dear friends and colleagues, I'm grateful to the Media Initiative for Human Rights for hosting this event and giving us an opportunity to engage with esteemed colleagues on the right to fair trial in international criminal law, particularly today, as we witness the historic decision by the European Court of Human Rights in interstate proceedings, Ukraine versus Russian Federation regarding Crimea, where the court has found the violation of the right to fair trial due to the fact that after enforcement of the so-called accession treaty in 2014, by which Russia annexed Ukrainian territory, the courts in Crimea could not have been considered to be established by law within the meaning of the Article 6 of the European Convention on Human Rights. It comes in parallel with the 2 new arrest warrants issued by the International Criminal Court against high-level military commanders of Russian Federation for the war crime and crimes against humanity of intentional and indiscriminate attacks against civilian objects that came out earlier today. It's testament that the web of accountability works, and we should continue our common efforts. As part of those efforts, we need to ensure respect of the fair trial in wartime situation. When the violation of the rights to fair trial takes place in the context of and in association with an armed conflict against protected persons, in our case, in course of the ongoing international armed conflict between Russia and Ukraine, it could very well qualify as a war crime. It is no surprise to anyone that amidst 130,000 registered incidents of war crimes that range from willful killing, summary execution, torture and ill treatment, conflict-related sexual violence, unlawful confinement, forced transfer and deportation of Ukrainian population, including children, intentional and indiscriminate attacks against civilians and civilian objects. We are also investigating and prosecuting the war crime of depriving prisoners of war and civilian protected persons of the right of fair and regular trial. Let me briefly describe the patterns that we are observing in this regard. Firstly, in relation to Ukrainian prisoners of war, and then in relation to civilian protected persons. As a preliminary note, I would like to clarify that annexation of Ukrainian territories is illegal and constitutes an act of aggression in line with United Nations General Assembly Resolution 3314. Consequently, under international law, Russian Federation has no legal right to acquisition parts of Ukrainian territories and declare them as its own. These territories remain under the regime of military occupation, to which relevant rules of international humanitarian law apply. I will start with prisoners of war. In international armed conflict, international humanitarian law grants the prisoner of war status to members of the enemy armed forces that fall under the ambit of Article 4 of the Third Geneva Convention. As a result, the prisoners of war benefit from combatant immunity. It means that they cannot be prosecuted for the lawful acts of war committed in course of an armed conflict. Thus, the prisoners of war shall not be prosecuted for mere participation in hostilities. They can only be tried for commission of international crimes and/or ordinary crimes that were criminalized at the time the said act was criminalized in line with Article 99 of Third Geneva Convention. Most importantly, the prisoner of war shall be tried only by a court that provides essential guarantees of independence and impartiality, and in particular, the procedure of which affords the accused the rights and means of defense, in line with Article 84 of Third Geneva Convention. Independence is a functional attribute, implying that both the court as an institution and the judge as an individual representative of this institution should be able to perform their functions without interference from the state authorities. That is, autonomously adjudicating by applying the law to the facts. As for the impartiality, judges must not be personally biased and prejudiced or appear as such to a reasonable observer. Second aspect of the right to fair trial is that prisoners of war have to be afforded procedural safeguards in course of judicial proceedings in line with Article 99 and 105 of Third Geneva Convention and Article 75 of Additional Protocol 1. In particular, no moral or physical coercion may be exerted on a prisoner of war in order to induce him or her to admit the guilt. And the prisoner of war should be afforded judicial guarantees, including access to assistance of a qualified counsel. Unfortunately, we see that these guarantees are repeatedly violated in relation to members of the Ukrainian armed forces. For example, the members of the Azov Regiment and Aidar Battalion, upon capture by Russia, have been charged with the so-called participation in terrorist organization and so-called attempts to overthrow government of Russia's proxy regimes in occupied territories. These charges are primarily brought as a pretext to prosecute Ukrainian soldiers for their engagement in hostilities, rather than classification of violence as a war crime of terror or terrorist act unrelated to the armed conflict. Notably, the Russian Federation designated Azov as a terrorist organization in August 2022, 3 months after the capture of Ukrainian soldiers, and as such, Russian courts have applied Russian criminal legislation retroactively in violation of the principle of legality. Unfortunately, we do not have access to the criminal proceeding files taking place in Russian Federation or occupied territories, but it seems that the Russian courts are collectively punishing Ukrainian prisoners of war for their membership in the units of Ukrainian armed forces. That is also prohibited under Article 87 of Third Geneva Convention. Lastly, Ukrainian prisoners of war are being tortured and ill-treated while in detention, often in order to force them into admission of guilt. In this respect, we have issued notices of suspicion against 3 judges who adjudicate case against 2 British and 1 Moroccan national. Let me also address the right to fair trial of the civilian protected persons. We all know that one of the biggest challenges is widespread and systematic nature of unlawful deprivation of liberty of Ukrainian civilians in occupied territory, that as a practice started in 2014 following the occupation of Crimea and eastern regions of Ukraine. In majority of instances, civilian detainees are not told of the reasons of detentions that often are criminal in nature, and as such, these persons appear before the courts in occupied territories and or Russian Federation. According to international humanitarian law, namely Article 64 of Fourth Geneva Convention, inhabitants of occupied territory shall in principle remain subject to the criminal legislation enacted by the territorial sovereign and the tribunals of the occupied territory shall continue to function in respect to all offenses covered by the said laws. Thus, Russian Federation is obliged to respect criminal legislation of Ukraine, the only internationally recognized legitimate sovereign of currently occupied territories. In addition, under Article 66 of the same convention, inhabitants of occupied territory suspected of violations of criminal legislation enacted by the occupying power in line with Article 64, paragraph 2, may be handed over to properly constituted non-political military courts on condition that the said courts sit in the occupied country. Thus, these military courts should have a limited jurisdiction in line with Article 64, paragraph 2 of Fourth Geneva Convention. Finally, the individual or mass forcible transfers, as well as deportations of protected persons from occupied territory to the territory of the occupying power, are prohibited regardless of their motive, in line with Article 49 of Fourth Geneva Convention. What we observe in practice is that individual civilian protected persons are brought before the courts under the Russia's proxy regimes that fall outside the ambit of the law of occupation. In certain instances, civilian detainees are transferred without their consent from occupied territories to Russian Federation and prosecuted before Russian courts. Substantially, Ukrainian civilian detainees are being prosecuted for crimes introduced in Russian criminal legislation after commencement of the war of aggression against Ukraine that they call special military operation, in violation of the nullum crimen sine lege principle, or that should in principle apply only to Russian citizens. For example, Ukrainian nationals being prosecuted for the crime of treason by Russian Federation in occupied territories. Lastly, the proceedings in Russia and occupied territories take place in blatant violation of judicial guarantees enumerated in Article 75 of Additional Protocol 1, including but not limited to guarantees related to the court proceedings, lack of qualified defense and legal assistance, forced confessions often induced under torture. We have already issued 3 suspicion notices for violation of the right to fair trial of civilian detainees against 3 de facto judges residing in occupied territories. Through the investigations past 10 years, we observe the practice whereas Crimean Tatars and indigenous people of Ukraine remain the most affected by the cases of the arbitrary deprivation of liberty by the Russian occupation administration on the Crimean Peninsula. Currently, My office had registered 92 criminal cases that relate to grave breach of the right to fair and regular trial provided for in Article 130 of the Third Geneva Convention and 147 of the Fourth Geneva Convention, representing a violation of laws and customs of war under Article 438 of the Criminal Code of Ukraine. However, this number does not depict the whole picture and all potential cases taking place in occupied territories and Russian Federation. That is why the work and monitoring undertaken by the international organizations and civil society organizations is so vital for us to help us in identifying, tracing, and collecting information related to cases of violation of the right to fair trial of Ukrainian prisoners of war and civilian detainees, as well as related materials that could be gathered via open source intelligence. From our side, we stand ready to cooperate with civil society organizations on this matter, as well as provide assistance to the potential victims of this war crime via our Victims and Witnesses Coordination Center of the Office of Prosecutor General. Thank you, dear colleagues, for your attention.
Thank you, Prosecutor General, for your very comprehensive remarks. I think we're going to be basing most of our discussion around them, and we're going to be analyzing and looking for ways forward, because certainly you outlined all the challenges that not only domestic authorities but also international communities face with, and we need to find ways to, once there is a judgment from the European Court of Human Rights, it needs to be implemented, how it's going to be enforced, and so on. So we have just the panel for that. And I think, yes, we will come up with some ideas at least. All right, so I'm going to give the floor to the head of the Media Initiative, Ola. Media Initiative has been documenting and monitoring trials, and also obviously, as you saw in the video, they've also been documenting and talking to the prisoners of wars who have been exchanged, who have been freed, and they have a mass of useful information, and it's really interesting to see the patterns as well, the patterns that you have managed to identify in all of these sort of incidents, because obviously, as we've already said, this has been ongoing for almost 10 years right now, and as it was mentioned rightly in the video, Russian Federation has been perfecting its technique and its approach. So how does it? What have you found? How does it create what's the reality?
Thank you, Nadia, and so I'm grateful to our Prosecutor General for joining and to all of you for coming here, because this topic is, let's say, a little bit complicated, but still very important in terms of investigation of all the crimes that Russians committed in the occupied territories and continue to commit in the territory of the Russian Federation. Together with our distinguished partners, Zmina Human Rights Center and Crimea Process Control, the Media Initiative for Human Rights is implementing a project to monitor the so-called trials against Ukrainian POWs and civilian detainees. The project started recently, and so we don't have precise results of the monitoring, and we promise you to present special analytical report as soon as we have more information. However, we believe that it is crucial to bring attention to these cases now, as they are actively being conducted by Russian authorities, and to explain the international community that they have nothing in common with justice. And I think today's decision of the European Court for Human Rights is also an evidence that all those courts established by the Russian Federation in the occupied territories are unlawful, and all those decisions, as a result, are unlawful as well. I won't touch on the procedural or institutional issues in my speech. My colleagues who are more experienced in these areas will cover that part. I want to share with you the facts and patterns we are observing as well, documenting war crimes and grave human rights violations to the Russian regarding to the Russian aggression in Ukraine. First of all, I should say that it is not easy to to monitor physically all those trials in the Russian Federation and especially in the occupied territories. Nobody has access to the especially newly occupied territories. We have even not gray but black zone of newly occupied territories. We know that there are a lot of proceedings are investigating by Russian law enforcement bodies, but nobody, even Russian lawyers, want to go there because of the security measures, because it is dangerous for them. But even in Russia, it is quite dangerous to monitor so-called politically motivated cases in the courts. Because as far as the Russian FSB or other law enforcement bodies are aware that somebody is interested in this specific category of cases, they started to actively follow this person, and the person is in danger to be interrogated or even to be arrested by the FSB representatives. So this is too complicated to understand how many cases there are, but still the Union for Human Rights, together with its partners, found out at least 204 verdicts that were passed by the Russian and occupying courts against Ukrainian POWs and civilian detainees. We believe that there could be many more judgments we haven't been able to uncover. Additionally, we can see hundreds of similar cases currently proceeding in the courts. So our main hypothesis is that all these trials against Ukrainians captured by Russia are part of a wider crime and purposeful policy of the Russian state. Russian authorities use their judicial system for the purposes of persecution of civilians, justification of their own crimes, and of course propaganda. Regarding the purposes of the trial, we can divide the cases against Ukrainians in Russian courts at least into two categories. First, this is the case against civilian detainees. And we assume that this is a continuation of the crime which starts from the detention of the person, because we know that so-called detention crimes of Russians in the occupied territories has a systematic character and is a part of persecution. So those people are detained, they are kept for a while, or for maybe sometimes it's for months, sometimes for years, and then we see how those cases occur in the Russian courts. So we understand that all those trials are only the part of this larger systematic Russian policy of persecution. The second category is the cases against the POWs, and so this is a little bit different category because, but also the systematic policy. For example, what you see for now about the case you've been able to see in our video, it's about we have a lot of cases against Mariupol defenders. Why are they doing this? Is the most common questions from the international experts. They always ask us, what for? Why do they need these trials? And in this case of Mariupol defenders, we see the purpose very clear. They want to accuse them of crimes committed by themselves in Mariupol. They want to switch the attention to create the new reality, legal reality, and to show maybe to create the alternative Bucha, for example, to show that to their mind, Ukrainians committed the same crimes that Russian did. So this is their purpose. We very clear can see when we see those trials against Mariupol defenders, and that's why during exchanging processes we don't see many of those soldiers and officers that was captured in Mariupol. They keep them, they hold them in the pretrial detention centers and prisons, creating all those cases. As my colleague Tatiana Petruchenko said, they make those people to coin some crimes that they committed in Mariupol against civilians, for example, by torturing, by creating inhuman conditions, and so on. So this is like an example of their purposes. But as also my colleague said already, it's not a new practice. We saw this while Russia occupied the Donetsk and Lugansk regions. And by the way, we had this investigation that we started in, if I'm not mistaken, in 2020, before the large-scale invasion. By this issue, by showing that Russia had effective control under the judicial system of so-called Donetsk and Lugansk Republic, we tried to show that that this system was created by Russians specifically for persecution of civilians, and we clearly see that they're trying to spread this practice into newly occupied territories. So, in conclusion, these trials have nothing in common with justice, it's for sure, and we have to investigate it, we have to document it. Unfortunately, it's not easy. Unfortunately, we need more resources for it. Unfortunately, there are not many people in the Russian Federation who can help us. Unfortunately, there are not many lawyers, for example, and I think Maxim, my colleague, will tell you more about it, who can even provide us with the information, because they are all in danger. And now we have this decision of Russian authorities to ban at least 81 European media in Russia, and it also will influence this situation, and it also will influence our work, our monitoring in Russia. But still, we will bring attention of the international community to this crime, and we hope that our colleagues from the Ukrainian prosecutor's office and maybe from the OTP will pay attention to these crimes. Thank you.
Okay, thank you, Anna. That's very insightful. So the Prosecutor General has set out the general sort of international framework and departments, right, where the crime is occurring, or the violation, the alleged violation is occurring, and what has just talked about the reality of the situation as we know it. Obviously, the Office of the Prosecutor General, especially our department, has been investigating and documenting this for many years now, and you probably from your side also have seen certain departments. What are the but there is a need to reconcile it with the domestic processes, because that's the legal setting where the investigations and prosecutions will be occurring. What are the main challenges that you've managed to identify, and what are the prospects considering the sort of domestic framework, one of the prospects of release these people for committing this violation to account.
Thank you. Thank you for inviting me and for the opportunity to give you a report about our work and the problems that we are facing during our investigations and the prosecution. Yeah, it's really that it's not the new pattern in the behavior of the Russian Federation's officials, because we are facing with these situations from the very beginning of the Russian aggression in 2014. They have a lot of cases that the Russian investigative committee investigate against our officers from the armed forces of Ukraine. They were indicted for the commission of the war crimes, for example, sharing of the civilian objects. And when we start to review these materials that were able to get in the open sources, we saw that the Russians indict the persons for a committing of a crime that the person can't commit this crime. For example, some of the Ukrainian officers were on the retirement when these actions were happened. Some of them were on vacation and it was not in Ukraine in this period. And some of them were serving on the other units. What it shows to us, it shows that the Russians try to use any opportunity to discredit our armed forces, to discredit our country, and to show that the invasion of the Russian Federation in Ukraine was like from the other side, we also see that they are using this opportunity not only in their domestic courts, they were trying also to discredit Ukraine in the eyes of the international community, because at least 7,000 complaints that were sent to the International Court of Human Rights was sent by the Ukrainians from the occupied territories. We get the list of these persons and start to investigate this case. We ask our border service to make the interview of these persons during they were crossing the border from Ukraine to other countries. And what we see that a big amount of these people were not given powers to the other persons, to the Russian lawyers, to send this complaints to the court. From the other side, we see that, yeah, this person was the victim, committed by the, was the victim of a war crime, but this war crime was committed by the Russians. But Russian lawyers made these statements, false statements from these people, and sent it to the ICHR to discredit Ukraine and to show that Ukraine committed these crimes, and it was not true. Well, in the end of the day, we saw that almost 90% of these complaints were false, and they contained false information about the Ukrainian and about the Ukrainian activity on this territory. The further investigation shows us that we were right, because we captured some prisoners of war from the Russian side or from the Zero proxy, and we get the testimonies from them that shows us that Russia or some military units from the Russian Federation committing such crimes as shelling for the civilian objects and even shelling for the civilian objects from the battle line, to show that it was making by our armed forces. Why is the reason why Russia acting in such way? Now we see that they are trying to excuse their own actions in Ukraine. Well, during the Security Council from the Russian Federation in February 21, 2022, a few Russian officials told that there is a genocide in Ukraine and we need to support this population of the Donetsk and Luhansk People's Republic. We need to protect them. After this, within in a few days, made a public statement and also says that it was the genocide in Ukraine and it was one of the reasons why they decided to invade Ukraine. But at the same time, from the battlefield documentary of the Russian army, we see that it was part of the planning of the full-scale invasion, part of the plan of the aggression, because from the very beginning of the February 2022, the information in these battlefield materials showed us that they were preparing to invade Ukraine. They were preparing their groups, they were preparing their ammunition and armor, battle machines to invade Ukraine, and it was just like the mask to hide their real aim and intentions. The biggest challenges for us during the investigation and the prosecution of such cases is the collecting of the evidences, because unfortunately we see that the Russian Federation is not released the persons who was on the Russian investigations. But what we see, we can ask about these persons in other prisoners of war from Ukraine, from Ukrainian armed forces who are back in Ukraine. We're asked about this in the persons from the other states who were fighting on the side of Ukraine as the members of the Ukrainian armed forces, and they told us the same. We are collecting this information in witnesses, from the witnesses and the victims, and they can give us, for example, the examples of the court decisions that were made by Russian judges, made by Russian prosecutors and investigators. And these pieces of the information give us like a helicopter view on the situation that is existing in the Russian Federation. Unfortunately, they are using these mechanisms just to discredit Ukraine and to harm our prisoners of war and civilian hostages. And well, the interesting situation from the one side, they are told and make the public statement. For example, Tolstoy told that the foreigners who are fighting on this Ukrainian side and they are members of Ukrainian armed forces, they are not combatants, they are mercenaries, and they are sentenced them for participating in the armed conflict. But at the same time, they are changing them as the prisoners of war after a few months after the beginning of the court hearing. Well, it shows us that they have the double standards and they are using the domestic law, international law in such way as they want to use them.
Okay, thank you. Right, next, we're going to hear from Dr. Marchesi. Good. It's going to be interesting to hear how the international criminal law classifies this violation, what are the parameters, and also obviously with these domestic challenges, even though the domestic authorities are investigating and also prosecuted these cases mostly in absentia, but still there are prosecutions in domestic courts. How does it relate to the international criminal law framework, and what role can the ICL play to assist in bringing to accountability the perpetrators?
Thank you so much, and well, thank you very much for having me here and to organize this event, which is incredible. Having dedicated my PhD to the war crimes related to the denial of judicial guarantees, is amazing that we finally have some attention to these issues. So really happy. And today I will focus my presentation, in fact, on the war crime of the denying of a fair trial in international conflicts, which is of course relevant for the Ukrainian situation. I will have this PowerPoint for you to help us navigate the topic, which is quite technical. Preliminary disclaimer: views and opinions expressed here today are fruit of my academic research and really don't represent the opinion of my current, former employers and colleagues at the international. So, dystopian forms of justice are definitely not a fantasy, as we've seen already. State and non-state groups frequently employ unfair trials as a formidable weapon in war. They depriving suspects and accused individuals of fundamental judicial guarantee or denying them a trial altogether. And this is what's happening, as we've seen already in Ukraine, which is certainly a notable example of this. Such infringements unfortunately culminate in indefinite detention, executions, and they are often part of a broader pattern of crimes, such as torture and enforced disappearances. International criminal law considers depriving persons taking no active part in the hostilities of a fair trial as a war crime, both in international and non-international conflict. Although there are distinctions between the two crimes. In international armed conflict, we have what I call the war crime of denying a fair trial, and in non-international conflict, the war crime of sentencing or execution. The history of this crime dates back to 1863 US Labor Code, which provided that during armed conflict, certain categories of protected person cannot be killed without a previous trial. Subsequently, in 1907, the Hague Regulation on Laws and Customs of War provided that spies only should not be punished without previous trials. And then in 1999, the Geneva Convention relative to the treatment of prisoners of war afforded prisoners of war suspected of a crime of judicial remedies, without, however, prohibiting or let alone criminalizing the denial of fair trial as such. After Second World War, the Allies held numerous trials to prosecute and convict Axis members for the war crimes committed during the conflict. For the first time, some of these trials involved charges related to the denial of a fair trial, the most famous of which is the so-called justification, where 16 German judges, prosecutors, and officials involved in the Nazi regime administration of justice were convicted for having utilized the denial of a fair trial as a powerful weapon for the persecution and extermination of all opponents of the Nazi regimes and also different races. As the US military tribunal in Nuremberg powerfully stated, the dagger of the assassin was concealed beneath the robe of the jurist. The UN War Crimes Commission chairman observed that already at the time, the customary law of war required, and I quote here, for anyone, a combatant or no combatant, to be executed or otherwise punished as for an offense against the laws of war, he should first be tried and sentenced by a court whose jurisdiction is recognized by international law. Moving from the experience of the Second World War trials, the 1939 Geneva Conventions prohibited for the first time as a great breach of the convention and as a war crime the willful deprivation of the rights of fair and regular trial as prescribed in the Geneva Convention to prisoners of war and civilians, and this is in international armed conflict. And the references are Article 130 of the Third Geneva Convention and 147 of the Fourth Geneva Convention. And then in non-international conflict, we have Common Article 3. Notwithstanding the fact that these crimes dates way back, the case law on these crimes is quite sporadic and either inconsistent or vague, as the crimes are starting only now to be prosecuted both at the national and international level. And scholars as well have been quite reluctant. At the international level, the war crime of denying a fair trial in international conflict has been prosecuted and tried only in 2 cases of extraordinary chambers in the Court of Cambodia. And in non-international conflict, the Halasan case of the International Criminal Court represents indeed a historic first, and the judgment of this case will be delivered tomorrow. However, we might have more cases in the near future at the international level, hopefully. In fact, the 2019 report on preliminary examination activities published by the ICC Office of the Prosecutor already claimed that the war crime of denying a fair trial in an international conflict has been allegedly committed in the Ukraine and Palestinian situation, and by then the situation. Understanding of the ambiguous rules governing these crimes remain limited, and the challenges they pose have been pretty much overlooked. The absence of court-effective prosecution undermines the principle of legality and legal certainty of the law to the detriment of defendants, and jeopardizes the legitimacy of international. My PhD research has stemmed in fact from the pressing need for a comprehensive investigation of the crimes to solve the challenges in interpreting and applying the crimes by establishing a systematic legal framework the national and international jurisdiction could offer. And I will now give you an overview of the legal framework governing the war crime of denying a fair trial in international law. So starting from the contextual element of the crime, it's necessary that the war crime of denying a fair trial, as any other war crime, of course, has a nexus with the armed conflict, which means that the conduct underlying the offense needs to have occurred in the context of or to be associated with armed conflict. It's critical to avoid assuming that any act within the conflict automatically constitutes a war crime. And a restricted nexus approach is definitely fundamental to distinguish real crimes from ordinary crimes and human rights violations. For the war crime of denying a fair trial, the criminal proceedings have a nexus with international conflict when they concern the trial, either generally by a military tribunal of prisoners of war that were caught during the conflict and suspected of having committed a crime, any type of crime indeed, or B, the second option, the trying of civilians, in this case by military or non-military tribunal, suspected of having committed an offense which is in this case related to the conflict, for example, treason. Let's move now to the material element of the offense, meaning the deprivation of the right of fair regular trial. What does it mean? The interpretation of this crime must account for the inherent fluidity of the right to fair trial. A one-size-fits-all Western-centered view of human rights does not apply universally. The right to fair trial is indeed influenced by contextual legal, cultural, and practical factors. And hybrid or domestic courts may therefore be better suited than international ones to try this offense, as they know the context. International humanitarian law and not international or regional human rights law should be the point of reference when interpreting this crime, when it comes to the identification of what is a protected person, who is the protected person, and of the relevant judicial guarantees, the violation of which may trigger criminalization. However, not all violations of international humanitarian law equates to war crime. A threshold of severity must. The judicial guarantees provided by international humanitarian law can be interpreted in light of the most universally accepted human rights sources only by means of what is called a contextualized approach that takes into account the peculiarities of the armed conflict as well as of the specific context. This war crime does not intend to criminalize the violation of every fair right protected by international human rights law. Using international human rights law to expand the material scope of this crime beyond predictable boundaries contradicts in fact the principle of legality and would be contrary to the nature and objective of international law. In application of these principles, the war crime of denying a fair trial is materially satisfied when prisoners of war and civilians are deprived of a fair and regular trial as a result of violation of judicial guarantees provided in the 1949 Geneva Convention, particularly the 3rd and 4th one, and Article 75 of the First Judicial Code of the Geneva Convention by way of omissions or omission within the proceeding or because no trial was occurred. So how do we ascertain when a violation may trigger the war crime? Well, in my PhD thesis, I proposed this. I suggested that the following two-pronged task need to be tasked. First, the question that we need to answer is a violation like so serious as to jeopardize the very core of that right? And second of all, is the fairness of the trial as a whole jeopardized? This approach allows taking into account the reality of the situation on the field and encourages this respect of international law, but avoiding criminalizing the failure to abide to under the target. Very much our. Let's move now to the mental element of the crime. So it's important to underline here really the critical function of the mental element in crime, which is to identify a criminal and blameworthy act committed with intent and knowledge, very distinct from human rights violations. The war crime of denying a fair trial should be considered satisfied, and at least this with the ICC system, when the offender has knowledge that they're violating judicial guarantees to bring about the denial of a fair trial, and either they carry out the conduct with intent to determine the denial, and in this case we have direct intent, or B, is aware that the denial will occur in the ordinary course of event and carry out the outside the ICC system, this changes. In fact, the crime seems to be satisfied also with dolus eventualis or recklessness because of the interpretation that is generally given in customary international law to the word willfully, which is part of the provision. The crime requires that the perpetrator is aware of the denial of relevant guarantees and the fact they are essential or indispensable under international law. Mistakes regarding the application of the fair trial standard and the existence and/or meaning of the relevant guarantees without the intent to deny a fair trial could negate the requirement. So there is the need for careful case-by-case examination of the mental element, particularly when dealing with defendants who may lack legal knowledge or awareness of what was happening. Let's move now to the last element, to the perpetrator of an accomplice to the war crime of denying a fair trial. So addressing the challenge of pinpointing individual criminal responsibility for crimes like this one that inherently involve a collective action is quite difficult. And here I advocate for a discerning approach, focusing on an individual de facto role and contribution within the justice administration, emphasizing again adherence to the principle of legality, individual responsibility, and common. An attentive case-by-case analysis should be conducted then to assess the individual actual contribution. Specific functions are required to be charged as direct perpetrators of this crime. The war crime of denying a fair trial should be considered directly committed by insiders, meaning those directly involved, de jure or sometimes even de facto, in the justice administration, and in particular those holding important positions or having important specific functions in the proceedings, such as judges and prosecutors. There are very limited possibilities for other actors to be held accountable, which make this crime what it calls, what in German they call a special crime. Now some reflections on the legal framework. I really believe that the interpretation of this war crime should take into account the three different souls of this crime, which is an international crime imbued with human rights but applicable in wartime. So a really fascinating combination of three different words: international criminal, humanitarian, and human rights law, which render this crime really characterized by different forces pulling and pushing each other constantly in dialogue and sometimes even conflict. And in this legal framework, what I think is very important is that international criminal features and objectives are considered as paramount. It's also important, I think, to avoid an overuse of the criminal tool, adhering to the principle of legality. Adopting a strict legality approach in interpreting international crimes would help international criminal justice to be seen as impartial, predictable, legitimate, and depoliticized. In a historical moment, I think, in which legitimacy is crucial for international criminal justice. However, we have to admit that an inalienable fluidity will always permeate this specific crime. This inherent fluidity, far from undermining the crime itself, underscores the importance of a context-specific analysis of the crime. And international criminal justice, I think, should also make sure that this crime is used as a shield and not as a sword, avoiding questions of legitimacy and hypocrisy. So while ICL is equipped to address serious violation of judicial guarantees during armed conflict, I think it's important to manage also exploitation. It needs to be also a last resort instrument to stay true to its very nature and goals, and it should work in synergy with international humanitarian law and human rights law, which should remain, I think, the privileged tools to regulate and address such violations. This doesn't mean, though, and here are really my final remarks. This doesn't mean, though, that this crime should not be prosecuted at all, rather the contrary. So, since the denial is a very common form of experience or time, unfortunately, with tragic consequences on liberty and life that we've seen, the fact that these crimes are rarely prosecuted, possibly because of a false illusion that they are less tragic, less shocking, less sexy, this is a very missed opportunity, I think, for the international community. The crimes are in fact able to capture a very precise criminal phenomenon, and by prosecuting them, not only the interests of victims are better served, but also an important expressive function is upheld, as a clear message is sent out to the international community. Judicial guarantees during armed conflict do matter. So what is the way forward? It's particularly important, I think, first of all, to consolidate a clear legal framework over crime. Then it's important that courts and tribunals trying the war crime of denying a fair trial, be it international or international courts, uphold themselves the highest fair trial standard possible to avoid hypocrisy and to avoid really incurring in human rights violation themselves. And this is something that Ukraine will need to find. And it's extremely important that more awareness of this crime is raised. All relevant actors, including non-state-owned groups, should be appropriately trained, and awareness-raising activities addressed to victims as well as prosecutors and judges should be deployed. The recent prosecution of this crime, both at the international and national level, are a significant development for sure. Not only do they mark a remarkable step in the fight against impunity, they also allow the jurisprudence to progress, to test this crime and the probability of the commission. The crime should be consistently prosecuted and interpreted, in fact, for international justice to perform its role, and a normalization of this crime is quite necessary. Last slide. Well, the hope is that these recommendations proposed could be adopted in The Hague, but not here. The future of international criminal justice probably lies a few thousand kilometers from here in Palestine.
Thank you very much. This was fascinating. Next is another doctor, Nina Marchuk, and it's really interesting that the latter mentioned that there are 3 different regimes coming to play, right? ICL, IHL, and international human rights law. And so I guess I'd agree that in some way they may pull in different directions, but mostly I think if we're looking at the practical reality in Ukraine, they would probably be complementing one another. I know that there is not a lot of sort of case law and practical understanding how this crime or violation should be prosecuted, but I think in terms of the as a war crime, okay, we've heard from Delacta, in terms of the crime of persecution, I think they should be set apart, the war crime of a denial of fair trial and also the crime of persecution. Even though they overlap, I think they still, I might be wrong, and this is where you step in, Amina, with your expertise, your brilliant expertise, and it'd be interesting to hear, especially in the light of also the decision today from the International European Court of Human Rights in the Crimean case.
Yeah, thank you very much for giving me the opportunity to be part of this panel and to shed light on this rather exotic crime of the denial of a fair trial, which had been part of Russia's policy in the occupied territories since 2014. We already heard about the denial of fair trial as a war crime, both in international armed conflict and non-international armed conflict. I really have nothing to add to Dileka's brilliant presentation, but I'd like to bring attention to the possible qualification of the denial of a fair trial as an underlying act of persecution under the umbrella of crimes against humanity. It's very symbolic as well that we're having this event today, when the Grand Chamber of the European Court of Human Rights finally delivered the judgment in the merits in the case that Ukraine brought against Russia concerning Crimea. And it was quite fascinating to read the judgment. It's for the very first time that the European Court of Human Rights found the violation of Article 6 of the European Convention of Human Rights by Russia, by way of Russia expanding its legal practices and also extending its legislation to occupied territories. And in the judgment, which is quite lengthy, I just skipped through the judgment. I really have to dig in. It's the European Court of Human Rights emphasizes that it's a very unique judgment, and it's for the very first time that it had to deal with the application of domestic law in occupied territories. I believe that in the Ukrainian context, in order to capture the essence of the denial of the right to a fair trial, it has to double count as a war crime and as a crime against humanity or persecution. In light of the fact that prosecution, trials, convictions in occupied territories, they have been part of Russia's policy of repression and persecution. I would like to say a few words about the crime of persecution, just to make sure that all of us are on the same page. The crime of persecution is less exotic than the denial of a fair trial as a war crime. It's firmly entrenched in customary international law and treaty law. It goes all the way back to the early 20th century and was used for the first time, but also not in the legal sense of the word, to describe the Armenian genocide in 1915. The crime was included within the jurisdiction of the Nuremberg Tribunal, together with other underlying acts such as murder, extermination, enslavement, and deportation. However, the constitutive elements of the crime of persecution were not clearly articulated in the Nuremberg judgment. The judgment did describe factual circumstances surrounding the persecution of Jews prior to the war and during the war, but it also emphasized that the crime was not a standalone crime, and the crime of persecution could only be prosecuted if it was committed in execution or in connection with a war crime or crime against peace. The ad hoc tribunals that picked up the crime, in particular the ICTY, they did mention that there was a lack of clarity with respect to the interpretation of the crime of persecution. They pointed that it was unclear what acts may fall within the definition of the crime, and that this in turn created tensions with the principle of legality. Also, the letter emphasized some of the tensions that we see when we interpret the denial of a fair trial as a war crime. As it stands right now, the crime of persecution is defined as an act or omission which discriminates in fact and which denies or infringes upon a fundamental rights laid down in international or treaty law. The ICC defines the crime as severely depriving, contrary to international law, one or more persons of fundamental rights. And now bringing it back to the Ukrainian context and talking specifically about the right to a fair trial, we know that the right to a fair trial is a fundamental right, which is the bedrock of criminal proceedings, and it's the lifeblood of the entire judicial system. Therefore, the denial of the right to a fair trial in its seriousness may potentially fulfill the legal elements of the crime of persecution. In the Ukrainian context, the denial of the right to a fair trial takes place in various forms and shapes, as we already heard from the prosecutor and also from my other brilliant panelists. I would like to draw attention to various geographical entities where the denial of a fair trial took place in Ukraine. First, the crime featured prominently in Crimea since 2014, and it's a continuing crime. It still takes place nowadays. In Crimea, we see that the forcibly imposed Russian legal system and Russian laws have been used as an instrument of persecution against ethnic Ukrainians and Crimean Tatars who were opposed or were perceived to be opposed to the Russian regime. The targeted persons were detained and put through judicial process during which the fundamental procedural rights were violated. For those of you who are interested, it's actually quite brilliant to look at the at the judgment of the European Court of Human Rights, because in the judgment you can see the summaries of the judicial processes that took place in relation to specific individuals. So you can see the summary of all the procedural violations that were taking place. Just to sum up briefly some of the most appalling violations that we have seen, the defendants were kept in solitary confinement during pretrial detention for many months with limited contact with the outside world. They could not mount effective defense. The judges dismissed any requests coming from the defense, and in some instances, defense counsels actually sided with the prosecution. In many instances, Russian prosecutors instrumentalized anti-terrorism and extremist provisions. And as well, in many instances, the FSB will just plant a weapon or drugs at the apartments or buildings where searches were being conducted. And the person would be just the persons who were targeted, they would be accused of ordinary crimes under the Russian criminal code. In many instances, if not in all instances, the defendants did not commit any crimes. And in the cases where they were charged with terrorism and extremism, that this entailed really lengthy sentences. The prosecution built their cases by using the so-called secret or anonymous witnesses, which goes to the right to mount effective defense. And once defendants got lengthy sentences, they knew that the appeal process would not yield any results, and they were hoping that they would be included in the exchange fund. I remember 5 years ago, we were working together with Maxime. We were trying to create the algorithm how to prosecute the violation, the denial of the right to a fair trial. And I was actually really fascinated by that you were trying to do something similar in your PhD. In the Ukrainian context, we were arguing, at least the algorithm that we built, we were looking both at the violation of institutional guarantees and at the violation of specific procedural guarantees. And what I mean by institutional guarantees, it was clear from 2014 that the courts were not established in accordance with the law, and they were established in violation of international humanitarian law. As well, there were clear indicators that the courts were not independent, and then they were not impartial. So we were trying to build these cases in the Ukrainian context by saying the first step would be to point to the violation of the institutional guarantees that the court were not established in accordance with law. As we know, Russia denied the application of IHL in Crimea. The second step would be to look specifically for the serious procedural violations that took place during individual trials. And I think that this is something that you spoke about. However, in the Ukrainian context, the Criminal Code of Ukraine only has a broadly defined Article 438, violations of the laws and customs of war, which we equate to war crimes, but there is not a separate provision for the crimes against humanity. So we cannot prosecute the denial to a fair trial as a crime of persecution in the Ukrainian context. That's why we are talking here in The Hague, trying to bring attention to this trial, and if the ICC were to pick up this crime for prosecution, we hope that they would also see that the denial of the right to a fair trial may constitute both a war crime and a crime against humanity. I'll say a few words about Donbass because I'm sure Maxim has much more to say. He worked with real cases. In the period between 2014 and 2022, we see that the so-called authorities of Donetsk and Lugansk People's Republic, they applied the quasi-legal and quasi-judicial system to any person who was considered to be disloyal or was just in the wrong place at the wrong time. The violations in Donbass were even more appalling than in Crimea. People that were thrown in illegal detention facilities where they were kept for months without any charges. There was denial of due process. The detainees could not choose a defense counsel, could not even get one. there was no examination of evidence. Sometimes the trials took place for about 15 minutes. And most appallingly, the so-called courts of DPR and LPR, they felt entitled to pass on death penalty. I think that what we see here is just a pretense of a judicial process that was taking place in DPR and LPR. Donbas is changing post 2022, and following the full-scale invasion of Ukraine, what we see is that Russia is creeping in this newly annexed territories and is trying to do essentially the same what it did in Crimea. It's trying to impose the judicial system, it's trying to impose its legislation. However, we have not seen that, but the trials that we see in newly occupied territories and in Donbas right now, they take place with such appalling violations of the right to a fair trial that they can't even be compared to Crimea, which is a much more established system, because I think Russians have been operational there for about 10 years. The question, when we talk about the crime of persecution, this crime is tricky because it requires to prove something extra, and that extra is a special intent. The crime of persecution is a crime of special intent. You have to demonstrate that the perpetrators intend to discriminate the victims because of on account of their belonging to a specific group. And so the questions that have been asked many times in different international fora, if we talk about the discrimination which is taking place and persecution on which grounds, those of you who might have followed the ICJ case, the very first ICJ case that Ukraine brought against Russia, concerning the violations of the Convention on the Elimination of All Forms of Racial Discrimination and Terrorist Financing Convention, the ICJ judges had actually to look at the law enforcement measures that have been implemented by Russians in Crimea, and also at the trials that took place in relation to ethnic Ukrainians and Crimean Tatars, and they had to decide whether the law enforcement measures that were undertaken by Russia, whether that could constitute acts of racial discrimination, or whether it could have an adverse effect on the rights enjoyed by Ukrainians and Crimean Tatars. But we know the ICJ is a very conservative court, and if it has any good reasons to dismiss the case and make its life easier, it's eager to do so. So basically, the ICJ made a very brief review of law enforcement measures, the anti-extremism and anti-terrorism legislation which has been applied in Crimea. And they said, yes, all these law enforcement measures and all these trials, they have an adverse effect on the rights of Crimean Tatars and ethnic Ukrainians, but they could be explained based on the victim's political affiliation. And when we look at the grounds of discrimination in the CRD, they are limited, and the political grounds are excluded from the scope of CRD. So technically, the ICJ basically dismissed all these trials that took place in Crimea and did not find any violations under CRD. And I'm very happy that finally the European Court of Human Rights made the record straight today. And it did say that the prosecution and trials and the convictions, they could be assessed together with Article 14, the anti-discrimination article, and it could also see that the discrimination was multifaceted. It's not always that we can separate someone's political opinion from their ethnicity or from their national origin. If we adopt the CRD committee's approach on intersectionality, we can see that in many instances, the perpetrators discriminate on multiple grounds at the very same time. And I think that the value of the crime of persecution, the way it's being framed in the ICC, that there are a number of non-exhaustive discriminatory grounds. And here, most hopefully, the Office of the Prosecutor will become interested in looking at the denial of a fair trial as a crime of persecution under international law. I could say much more, but I think that I will stop here and I will give more to Maxime. So we have some time left for discussion as well.
Yeah, I think you'll have a chance to elaborate a little bit more during the discussion. Thank you, Irina, for your wonderful intervention, as always. Maxime, you've been a practicing lawyer for many years right now, and you've been working on the armed conflict. And what I've heard from the two brilliant experts is that the framework, the legal framework and the case law is not quite definitive and sufficient enough, and it's very difficult to prosecute the denial of fair trial as a war crime, and also the crime of persecution. It's ambiguous, and also there is no appetite, among the judicial institutions to actually prosecute it effectively, so that there is a clear legal framework and a practice that we can base it on. And so perhaps the result of that is that Russia has been feeling, as in many cases, the total sense of impunity, and the result of that has been that it has been advancing and progressing and honing its skill in setting up the system and in developing it and in rooting it in the newly occupied territories. What has been your assessment of the situation? Has it been, what's the progress? Has it been worse? Has it been the same? What's the
Thank you, Nadia. After this presentation, it's become even more difficult for me. And taking an opportunity that we have a broadcasting and that we have a very historical day today. And this roundtable takes place in a historical moment in the light of judgment of the European Court of Human Rights and 2 arrest warrants. I'd like to express gratitude to our Ukrainian legal team who represented all that time our country before the European Court of Human Rights and other institutions, and also Ukrainian law enforcement and representative of civil societies who supported, because it would not happen without your support. So thank you very much. So, and back to the denial of fair trial, it's very difficult to add something up to my colleagues. Maybe I can perhaps highlight some patterns of Ukrainian context, because I think that denial of fair trial as international crime possess significant challenges for Ukrainian law enforcement, as Andrei also mentioned, and Prosecutor General, and for our justice system at all generally. And why is that? Because I think there are so many uncertainties which Diletta confirmed during the presentation. And you can even imagine how it's difficult for the investigators to assess this crime, because as we know, the general rules that we have to assess the fairness of the trial, just as the whole trial. So you cannot just take separate violation of the procedural guarantees and claim that this is a war crime. So we have to assess the process and bring this to the prosecutor, and after that to the court. So I think it's very difficult. And I usually say that this is a gray zone of international criminal law, because there is not so much jurisprudence. Of course, we have some landmark decisions of the post-World War II cases when there were some trials that we can say that it was the trials about the denial of trial. The famous one is the Justice case, where the German judges were convicted, and also what is more interesting from the point of view of institutional guarantees, some people from the Ministry of Justice of the German state, just because they created specific legislation, they created specific directions, instructions for the judges, and they were convicted also for this war crimes. So, but after this, we don't have enough practice of the international bodies. Of course, tomorrow will be another historical moment. The ICC will deliver the judgment in the Al Hassan case, where the court probably will highlight some issues regarding the due process, which is very connected to our denial of fair trial, but it's still very complicated. Additionally, as you mentioned, the fair trial issues also very connected with the other war crimes like imprisonment, deportation, because if we take the Crimean context, a lot of people were deported just because of the decisions of the occupied courts. So it's pretty difficult to assess this crime in our national system, especially in the light of our Article 438, where it's regard us to the whole course of international law, and this is very difficult to assess. So I think that the general pattern which negatively impacts the due process is the legal warfare, which provided by the Russian Federation. And this is the first element of this is the disregarding of the international law in all cases. For instance, even now, when the whole world recognized the existence of international armed conflict, the existence of war, they claim that this is a special military operation, and the whole people who were detained since 2015 or something 14, I'm sorry, and after 2022, they recognize them as the person obstructing the special military operation. So so Russia does not grant them the status of prisoner of war. And so they, as a result, as the prosecutor general mentioned, they deprive them the privilege of the combatant, because they does not recognize the status of prisoners of war and the status of combatants. So that is why our people, our servicemen convicted for, I know, illegal crossing the state border, for instance, for storage of the explosive and weapon, for participating in the terroristic organization, for terrorism, extremism, and so on. So this is a clear violation of the combatant immunity, and I don't know if we have to assess the procedural irregularities when we have already the problem with this case at the very beginning. So this is a clear pattern. And the second pattern, which is, I think that I could add after my colleagues, is the use of torture to obtain the confessions and incriminating evidence. So all the process against our servicemen and civilians, they use the practice of they use the evidence which were obtained by the tortures. And it was also reported in the reports of the United Nations and the human rights organizations. And this is a very, very clear moment when we can say that this is a war crime, because European Court of Human Rights provided a concept which is called flagrant denial of justice. So flagrant denial of justice, one of this example is the sentencing, the judgment based on the evidence obtained by the torture. And we have a lot of these cases. So I can continue, but I think that we run out of time.
Yeah, we have half an hour for questions. I don't know, is that enough? Is not enough? But if you have a couple of more points to add.
I'd like to add a few points regarding the transparency of the trials, because all I mentioned about the journalists. So it's really difficult to imagine that we can really document the cases which are in the occupied territories, because all journalists who are here or representative of the civil society, they just prosecuted for participation in such cases, just like observers. So when we have cases when such journalists were prosecuted and detained, so it's also one of this guarantee of the fair trial. The transparency, the judgment have to pronounce publicly, but we don't have it in our context.
And you could easily actually get access to the first Crimean cases, because the Russian register of cases was opened. But then they realized that this evidence was being collected by the Crimean prosecutor's office and other governmental agencies, so they closed the registers. Yeah, we did similar in Ukraine as well. We did close our register for some time, and especially it was quite sensitive when Ukraine passed on the first war crimes judgment against Russian prisoners of war. but then we anonymized the names, we just redacted the names and we make the register public again, so that information is accessible, but I'm not sure, but I'm sure that it's not being accessible in Russia.
Okay, so, I'm opening the floor for questions. Anyone? Otherwise, I'm gonna use my right of Okay, awesome. My question is to all of you. I guess we've talked about challenges and how complicated the legal regime and framework is, and what are the next steps in your opinion? What it should be? How do we sort of make progress in prosecuting the crime of denial of fair trial or the crime of persecution? What needs to be done as a first few steps as a priority?
Yeah, I'll start because I guess we are the body who is executing the law, but we are not creating something new. But we are still hoping that maybe in a few months, maybe in a year, we will have the changes in our penal code and we will have the crimes against humanity. It will give us more opportunities to prosecute these persons who are committing such crimes. Because for now we have the only article, Article 438, and we can prosecute these actions as the war crimes. But at the same time, we see that a lot of the action that the Russian officials committed inside of the country is not related to the war, it's just related to the peoples who are just Ukrainians or pro-Ukrainian. And it's for us, it's a big difficulty and it's challenging for us to prosecute such a case. Yeah, and we are hoping that it will become changes in our penal code that will release our possibilities to investigate and prosecute such a case.
Well, I'm sorry, as a human rights defender and civil activist, not as a lawyer. First of all, we have to raise awareness about the problem because as my imagination is that there is not much information about these trials, and there is not much understanding within the international community, even the OTP. We try to discuss this, that this is a real crime and it is systematic and a large scale crime. The numbers of those verdicts that we have, the numbers of those cases that we observe in Russian courts and courts in the occupied territories, shows us that we have to investigate it. We have to understand the purposes of those processes and what is the purpose of this policy. For us, it's absolutely clear that this is state policy, but to study these patterns and to understand what they're doing and what for they're doing. I want to emphasize that they have at least 2 commanders of Ukrainian Marines from Mariupol in their captivity, and we still don't see the proceedings against those commanders. They keep them for some occasion, and we can assume that they will use those POWs, higher level officers, for some special tribunal, maybe alternative tribunal that they can create, like in parallel with the tribunal on aggression that Ukraine with the partners tries to create as well. So we have to predict what will they do further with those proceedings, with those trials, and to understand, I don't know, their strategy and to react on the strategy. This is very important to predict it.
I have two comments. Oh, I'm
No,
sorry.
no. Yeah, well, I'll be very brief because I touched upon this already in my presentation. I think that training is key and raising awareness is key. Like we need to train prosecutors and judges and yeah, the caseload is limited and we just need to start testing this provision.
Yeah, I hope that the Ukrainian authorities and particularly the Ukrainian prosecutor's office will start with Crimean cases. And it's the biggest incentive today when we look at the decision of the European Court of Human Rights. All these cases against very prominent Ukrainians and Crimean Tatars, they're detailed in the judgment of the European Court of Human Rights. When Ukraine was applying evidence to the ICJ and to the European Court of Human Rights, some of those target persons that were already released from captivity, so they gave witness statements detailing in great detail what happened to them in pre-trial detention. We actually have copies of judgment that were passed by Crimean authorities. So we do have evidence, but we've been sitting on this evidence for a number of years, saying that it's very difficult. We don't know what kind of violations we have to prove when we talk about denial of a fair trial as a war crime. But now the job for Ukrainian prosecutors is easier. At least you can make the reference to the European Court of Human Rights and say resolutely that there are clear violations of institutional safeguards, and the Crimean courts, they were not established in accordance with law. And then you can just work with the judgments that we have that were obtained through different parties. They're no longer confidential. I believe that some of the early cases that concerned mass demonstrations that took place on the 26th of February 2014, I believe that you can obtain these documents just by doing simple Google search. And you should just go through the judgment itself, go through the witness statements of persons who were subject to the judicial process, who were released. And I believe that that information in itself is sufficient to actually run very convincing cases in Ukrainian courts. I do understand the challenges that my colleagues are talking about, talking at trials that takes place right now against Ukrainian prisoners of war who are in Russia and we don't know their whereabouts. Basically, those people have disappeared. We cannot even trace their whereabouts. It's not possible to trace what happens in newly occupied territories, but we do have really good cases that we could use at least to build practice in this area.
But of course, with the domestic authorities, we need to safeguard our process as well because of the trials in Maxentia.
Yeah.
So we don't end up. Yeah, we have to be.
Yeah, exactly. We also have to make sure that with the trials in absentia, they comply with safeguards in the case law of the European Court of Human Rights. Although Russia is no longer part of the Council of Europe and notoriously exited, might be back. You never know. Yes, exactly. But still, it's necessary for Ukraine because it's a democratic country that wants to demonstrate its adherence to the rule of law to make sure that we comply with all procedural safeguards. And our biggest shot is to do trials in absentia. We should do that because this is the only way to preserve evidence. And we can later use this case law to build up other cases when more information will become available in 10-15 years down the road.
Thank you.
I think that we have to wait for tomorrow to see what ICC will tell in the Assam case.
Yeah.
And I we don't have to underestimate the institutional guarantees, as you said, but right there is a problem because, as I said, it's still unclear this borderline between human rights law, international humanitarian law, and international criminal law, because even today, when we discuss this judgment of European Court of Human Rights in terms of extension of the Russian legislation on the occupied territories and establishing its own judicial system, which court declared illegal, and the court also stated that all the courts are not established by the law, and this is a very serious conclusion. And here is the question: because in the IHL, the additional protocol prescribed, and the letter would correct me if I'm wrong, because in the additional protocol, there is a term regularly constituted. So does it mean that this is the same terminology with the European Convention of Human Rights? And if yes, can we say that, okay, that the establishing of this illegal judicial system constitutes the war crime of the denial of fair trial, because the European Court clearly stated that this is not a court established by the law. And this is what we have in the additional protocol. And this is what we can also think in terms of bringing the judges, or maybe to think about the command responsibility in the denial of fair trial. Is there a command responsibility, or only prosecutors, investigators, and judges are responsible for committing of this crime? I don't think so, because I'm thinking it reminds me of this justice case about this statesman, the government, when the ICS from the Ministry of Justice, when they were brought to the responsibility for the creation of legislation. So usually when we talk about fair trial, we're thinking about some irregularities in the court, to right to interrogate the witness or the experts, to have a counsel or something. We're thinking about presumption of innocence, but we usually underestimate the institutional guarantees. And back to this policy of disregarding of international humanitarian law. So the essential point in this cases is to recognize the application of the IHL in the concrete case. So I'm a combatant, I deserve for having a combatant immunity, not to be prosecuted for the mere participation in hostilities. But the court reject my arguments. Can we say that this court is impartial? I don't think so. And this is also about institutional guarantees.
That was actually really interesting in the judgment of the European Court of Human Rights, because the judges said, in light of the conclusion that the courts were not established by law on the territory of Crimea, we're not going to look at the question of independence and impartiality, because that's redundant.
Yeah.
So
We don't go.
if the courts are unlawful, like, why should we look at the independence and impartiality? And then it's not necessary to go down the road.
And even more goes to the
procedural
procedural
guarantees.
irregularities, right? So this is a problem. So the conclusion is to think about command responsibility and go further.
Especially in the Ukrainian legislative framework. Yeah, okay, we have a question.
I had a question. Earlier this month, Brenda Hollis, who's the lead investigator on Ukraine for the ICC, said that they would now start focusing on crimes related to detention and as a result of detention. And I wanted to ask Andrei if this, if he thinks that these kind of trials against POWs and civilians who are detained could be part of that, and if that is something that might be better prosecuted by the ICC because of the crimes against humanity legislation and the legislation that the ICC has compared to Ukraine.
Yes, we hope that these crimes will be also be part of the investigation, because it's a lot of crimes committed against the prisoners of war in civilian hostages and detention facilities. It's not only the broken on the right of the fair trials, it's like the tortures and illegal imprisonment of the civilians, a lot of other crimes committed there. We are focusing, we are trying to collect the information about the committing of all of the crimes. And we are also sharing this information with the ICC. And what we can expect from them is that they will cover by their own investigation all of these actions. It will be a success for us, because from the one side, you are right that they have more powers to investigate different kinds of crimes, and it's also the crimes against humanity. We have this possibility for now, but at the same time, it will be shows to the whole world that these crimes committed in detention facilities might be punished, and it might be reacted from other countries, not only for Ukraine. Yeah, we hope that they will also investigate these cases, but we'll see.
If I may add, I think it's also a part of prosecution strategy to prosecute crimes which are more feasible to prosecute. Taking a step back, while we are looking at the deportation of children as a war crime, why we didn't pick up forcible transfer of children as an underlying act of genocide, which was much more interesting crime, and everyone was saying that this is an act of genocide. But the prosecutor is just going for something which is safe choice. And clearly there is a lot of information, a lot of evidence. And now I think that various civil society partners, they galvanize their efforts in bringing evidence to the ICC on illegal detention and torture and inhuman treatment, because they know it's being prioritized by the office of the prosecutors. But that, despite the fact that certain elements of the violation of the right to a fair trial may be prosecuted under other subheadings, it does not mean that we should not focus on the denial of the right to a fair trial as a war crime. I think it's also a golden opportunity for the ICC as an institution to try to prosecute other more exotic crimes that were not prosecuted in ICL for a very long period of time. So I do understand why Brenda wants to prioritize unlawful detention, torture, and other inhuman treatment. But I do think that the office of the prosecutor can pick up other crimes as well, because it will give a much more nuanced legal qualification of the conduct that we are thinking about.
We understood from the discussions with the Ukrainian field office, it is also an issue of their resources. And when we try to show this, to show them this puzzle, which is a large crime, and we assume that it is a crime against humanity, and we as an organization are trying to build a case on this. And it's my feeling that they are afraid of large cases, and they are focusing specifically on that Irina said, specifically on doubts, crimes as tortures and sexual violence or inhuman treatment and so on, and extrajudicial killings as well. So this what they are going to start from, and then we hope that someday we will show them, or they will see the whole picture, that this is the systematic policy of the Russian Federation, which includes different crimes, and starts from the enforced disappearances or arbitrary detentions, and ends with the trials we are discussing now.
Okay, thank you.
To really cheeky ask 2 questions. You mentioned earlier that there was 204 convictions. Can you explain, one, what that number means? Is that like the total number of convictions since the annexation in 2014? Because that seems very low to me. And also, is this specifically focusing on crimes that are related to the invasion? So for example, soldiers, or is this also including things like drunk driving incidents or something like this? And my second question is about kind of the ECHR ruling and talking about the forced citizenship. This was one of the things that was discussed that the Strasbourg court was very critical of. And I'm kind of curious what the legal framework might be in Ukraine, or I guess maybe in Russia, to prosecute this. It's not something that comes up very often, I guess, as an international crime.
It's a bit of outside of the scope of this discussion, but if the experts don't mind to answer that question.
Yeah, thank you. I will answer the first one, and then if somebody wants. This is a very good question, because I was talking only about the convictions after the large-scale invasion, after the 2022. And it's both against civilians and POWs. And, they have special legislative framework for terrorism, for example, and they considered, for example, Azov battalion or Aidar battalion as terroristic organizations. And so they accused them in participating in terroristic organizations. Also, they accused everyone who somehow connected with those battalions. For example, civilians who helped them, or civilians who served as not military, but civilians, for example, cookers, drivers, and kinologists is the right word, for people who deal with dogs. So they consider them as terrorists, and so and they convince them as terrorists, for example. For example, we have just today in the morning, we had a verdict against local from Melitopol. It is occupied city in the south of Zaporizhia, of the Zaporizhia region. He also was accused in extremism, and he's convinced today for 14 years. So he's made statements while during the court hearings about tortures, about inhuman treatment that was committed to him, and but judges didn't even pay attention for those statements. And every day we see new and new convictions, and so the scale of this so-called justice, let's say, is so big that someday we will have thousands of those cases, because we have like cases, group cases, as I mentioned, Azov, Aidar, and others from Crimea, Hizbut Tahrir, for example, a religious organization prohibited in Russia, but absolutely normal in Ukraine. But we also have a lot of individual cases. And this one pager that we gave to you, we point to the reports that make these trials, and there are not a lot of them, because we don't know. It doesn't mean that there are that other courts don't proceed these cases, but we know only about this, and and we don't have enough information because of closed registry, because of no access to the occupied territories and so on.
No, I only, I know we don't have time to discuss forceful imposition of citizenship, but I would like to refer to a brilliant blog post which was written by my colleague last week, Gayane. It was published on the 18th June 2024 by Eagle Talk, and it's called Forceful Imposition of Foreign Citizenship as Discrimination and Breach of the Right to Respect for Private Life, where she goes through the recent decision of the United Nations Human Rights Committee. It's called Brazil case. And this case specifically deals with the forceful imposition of Russian citizenship as discrimination. And I think it's, and she actually compares that decision with a very drafted ICJ judgment. It makes a very interesting comparison. I would really encourage you to have a look at that and then try to today's judgment. Because I think it's interesting to draw certain comparisons from all the jurisprudence coming from different international fora.
Thank you, Irina. Carolyn, last question, because we are.
I'll be quick, and it's I think mainly for Olga and Andre, because, and I want to go back to what Nadia asked about first steps. You know, I'm a foreigner, I'm a prosecutor, but I'm a foreigner, so I'm not a Ukrainian lawyer. But it seems to me, and nobody mentioned this, that a first step in justice, accessing justice for these violations, would be procedural reform, so that, for example, Andre's services aren't specifically required to investigate every single individual perpetrator, to allow for the strategic approaches that what your other three colleagues were discussing to follow. And I'd like to know what you think about that. For me, that seems to be, but like I said, I'm a foreigner, that seems to me a very important first step.
Yeah, it's difficult for us because for now we have more than 130,000 of war crimes, and we need to prioritize our investigation. We need to prioritize our investigators what they need to do it first time. We're trying to collect as more evidences as we can, but for example, in our security service, 700 systems of it. We have only 700 investigators on all of Ukraine, and war crimes is their part of the investigation. Our national police have more investigators, but they can have a right to investigate war crimes till the prosecutor will give them discipline. That's why we're prioritizing our work, and we are trying to collect as much evidence as we can, but we are prioritizing our work and investigating more difficult cases, more cases that related to the persons who commit crimes, more high-ranked persons, to show that all of the Russian officials are involved in this process. All of them are committing the war crime.
Our wish is that our prosecutor's office consolidates all those separate episodes and to see it more systematically. But it is also an issue of our legislative framework.
Exactly.
Because Ukraine didn't ratify the Rome Statute, and every time we emphasize this issue, and I think that we are very close to this. I hope. I'm afraid to say, but I think that we are very close to this moment, and someday the Rome Statute will be ratified. But it's also an issue of command responsibility. It's also an issue of the crime against humanity, which is not even mentioned in our criminal court. So the prosecutors and investigators are not obliged to investigate it systematically. So they look at very specific cases, very like individual, let's say, and that's why we see, for example, our organization also monitors our domestic trials. And what we see is, for example, the very big investigation and large court hearings against soldier Petrov, who steal washing machine in village Ivankiv, and this is like and they consider it like a very successful case, and
Village of the war crime.
This is a problem because they had large scale work to do for very not important cases, and we miss something that is much more important. And for example, like this case we're talking about, it's not about Andrei's department, of course, but in the level of the regional prosecutor's office, there are a lot of such problems. And, yeah.
So basically, the answer to your question is yes.
Yeah.
Okay, thank you very much.
We will discuss after, and we invite everyone to
They have a small session there in the cafe with drinks and
to have some.
to have a discussion all together.
Let's discuss together.
Yeah.